was a court hearing at Honorable Supreme Court today about the NEET case, and it was done by the bench of 3 judges, including the CJI of India. And their observation is number one is they have put it for the next hearing on 11th July. So the matter is sub judice. Few points which came as prominent important points after today's hearing, and that all students and parents engaged, involved, concerned about NEET must know. Number one point that the Supreme Honorable Court said is, if the sanctity of NEET exam has been affected, which they also accept that has been affected, in that case Re-NEET will be done. But they know that conducting for 24 lakhs people is too much, so they want to know certain cases. Number one point, let me take you through point wise. One, the court is concerned about sanctity and looking for this to be maintained. If not, NEET may happen. Second, the most important point that the court has said is they want to know the complete details and the logic of the people who have filed the petition to conduct the Re-NEET exam once again. This is a very strong empathetic step which has been taken by the Honorable Supreme Court to understand what is the pain, suffering, difficulties faced by the students and parents, what is their agony, what is their thought process. And it's a very empathetic stand taken by the Honorable Supreme Court. And if you know it, today also in the hearing, this was one of the most prominent points which I heard first, and then the hearing was taken forward. So the court will give a lot of weightage to these petitions that have been filed. Next point where the court said is, see, if the tainted students or the students who are involved in these types of illegal activities, if they cannot be separated or segregated, then Re-NEET is necessary. So now what happens is, if you are not able to separate who all got the benefits, who all did not get the benefit, if you are not able to quarantine, then in that case Re-NEET will be conducted. So now the onus is on two people, two organizations, one NTA and second CBI. If CBI inquiry and NTA is able to give the details and prove, convince with the logic, with the details, information that this was quarantined and was localized to only specific centers or states or only few people, only in that case the Re-NEET may not happen. Now with the cases FIR being done in Patna, Bihar, Delhi, Rajasthan, Maharashtra, Gujarat, Jharkhand, these are almost 6 states plus one Delhi if you consider Punjab, Haryana connected, 7 states. If you keep the northeastern states, 7 states away, out of 21 states of our India, that is 7 states here, out of 21, 6 states have already filed reports, which is almost 30% of the entire country. So this becomes a serious issue. And if CBI and NTA is not able to give their quarantine report, in that case it becomes a big possibility that the court may go for Re-NEET. Okay, the court has given a date to submit the submissions of all the petitioners, lawyers asking for the Re-NEET that we have discussed already. The court has also directed the CBI to file a status report of the investigation which they have done so far, along with the materials which has come to light. So if the investigation shows that this content was shared freely on WhatsApp or any social media, then it becomes a concern. If it has been seen that people have done only in specific places, they have kept the secrecy of sharing this NEET paper leak, in that case the court may take a decision forward on that. Okay, and the Honorable Supreme Court has also asked NTA to give the details on the following points. One, the steps that were taken by NTA to identify cities or centers where the leak took place. NTA has not done this on the first steps, so that brings NTA under doubt. One. Number two, now the court doesn't want only to know that what are the which are the centers that they have segregated where the leak has happened. They also want to know, point number two, modalities followed by NTA for identifying the same. If you identified a center that there was a paper leak here, what was the modus operandi that you followed to identify that center? Have you taken FIR in cognizance? Have you taken FIR in consideration? Have you taken parents, students' complaints collected from all across the country? Have you worked on it? I think these angles are going to come into this picture. Number of students who have so far been identified to be beneficiary. I think NTA has already talked about this on 1563 students. They have concluded. Okay, if the number goes up, NTA's explanation comes under doubt scanner. Okay. One thing which is very interesting, the court has said is a policy decision will have to be taken by the government on the status of counselling. The government, what they have done, that we are going to run the investigation, we are going to see the case, you take a decision on whether you want to start with the counselling. And the Honorable Supreme Court has already told, if we come to understand that the sanctity was compromised and it was not localized, in that case we'll cancel it. I think with the UGC NET being cancelled, with Hathras stampede happening, I think there is a lot of backlash against these organizations which are conducting this and the way it is being run. So government, I don't think, will take the risk of running the counselling before the 11th July verdict. And so let's see what happens on 11th July. But there are a lot of questions, and I think the court is going step by step point was in taking it forward. So with the next hearing scheduled on 11th July, stay tuned for further updates.